Hi, this is Paul Staley. I wanted to answer some of the questions that most commonly come up regarding the first meeting of creditors when it comes up in bankruptcy cases. So here we go.
Where is the courthouse for bankruptcy?
Well, the courthouse itself is at 325 West F Street, downtown San Diego. However, the first meeting of creditors does not take place at the courthouse. It has been taking place at the Westin Hotel, and this has changed hands many times over the years, so I'll just give you the address. It's at 402 West Broadway, San Diego, 92101. Currently, the meetings are being held on the 6th floor, and if you can get off the elevator at the 6th floor, there are really only two ways to go, so it's pretty hard to miss.
How long will this take?
You should plan on being there for as long as 2 hours. It would be really unusual for you to be there that long or any longer than that. However, it has occasionally happened.
Because it's downtown, should I plan to pay for parking?
You should. It's almost impossible to find a free parking space anywhere near this building. Although we do have some folks who like to park at Horton Plaza, which is about 8 blocks in the other direction, and walk to the hotel.
Who will be there?
Yes, well, it is called the first meeting of creditors, which is one of the worst misnomers you'll come across in the bankruptcy context. It sort of infers that there might be more than one meeting and that creditors might actually show up. Creditors typically don't show up at the meeting, and so you're asking yourself, why do we bother going? Well, because the trustee is going to be there, and we'll get to the trustee's questions in a minute. The trustee is required to question you under oath. I'll be there with you, and there will probably be several other people who will be on the same calendar. Usually it's a 1 hour or 1 hour and 15-minute calendar. So lots of people in the same room there to do exactly the same thing.
How long will this take?
The actual questioning usually takes between 2 and 4 minutes, really. And the reason that I tell clients to plan on being there for as long as 2 hours is we don't know what order the cases will be called in, and we don't know if there might be some case that gets really complicated ahead of us. So you gotta allow for more time than is necessary rather than not enough time.
Where will we see you?
I meet my clients right outside the meeting room, and there's a meeting area there. There are plenty of chairs. There are some handouts there, which a lot of people don't read till they get there. We will have provided those to you in advance. So it's right outside the meeting room.
Do I have to bring anything to this meeting?
To the meeting, you must bring a government-issued picture ID and proof of your Social Security number. And that can be in the form of a Social Security card. If you don't have that, there are other things that will work. You could use a W-2. You can use a third-party prepared tax return. There are a couple of other options as well.
Will the trustee say anything to me?
The trustees tend to work from a fairly common script, so we have a pretty good idea of the questions that they're going to ask you. I think what a lot of people worry about at the meeting is, is the trustee or the creditors going to line up in the room and cross their arms and give you dirty looks and ask you, how dare you not pay them? That is the furthest thing from what's going to happen at this meeting.
How long before I'm granted my bankruptcy after this meeting?
The final discharge in your bankruptcy case cannot be issued until at least 60 days after the first meeting of creditors. Now, I'd like to give you some idea of what the questions are that will be asked by the trustee. They'll ask you first to state your name and address for the record. They will ask you if your petition and schedules were prepared with information provided by you to your attorney. They'll ask you, even though you signed your petition and schedules in about 8 different places under penalty of perjury, whether or not the information in them is true and correct. So far, I have never had a client say, "No, I lied. Please just put the handcuffs on and can convict me of perjury." It seems redundant, and some of these questions might even seem silly, but the trustee will nevertheless ask them. They will ask whether or not you've transferred property to any family members. They'll ask you whether you are a beneficiary on a trust or a will where someone has died. They may ask you, well, they will ask you if all the information in your petition and schedules was true and correct on the day that the case was filed. They'll ask you if you reviewed it. They'll ask you if you signed it. There's one trustee who will ask you if you incurred credit card debt of $5,000 or more on any one card. That's one trustee out of 7. We have no idea who your trustee is going to be until your case is actually filed. Once those questions have been asked, and that's a fairly complete list, the trustee will ask, are there any creditors present? Apparently not. Your meeting's concluded. You're excused.
What's the one thing you want me to know before I go to this meeting?
I want clients to know that we have, in advance of the meeting, provided the trustee with all of the information and all of the documents that the trustee has requested or which we typically believe that the trustee would want. So there really shouldn't be any surprises at the meeting. There very, very rarely are. So even though it seems like a big deal, it's fairly anticlimactic. Most of the time, most of the trustees will finish their questioning in, I would say, under 3 minutes. One of my favorite trustees is famous for finishing his in under 60 seconds.